Hi, and welcome to this video that's intended both for people very familiar with Smith and people not so familiar with Smith and people very familiar with the law and people not so much. Because the audience is so mixed, I think I will lose you from time to time as I talk through the background here. But if you have questions or want to follow up or get more detail, I am more than happy to respond by email, so don't hesitate. I'm just going to provide a few anchor points here, and then talk about how we got to Smith, which seems to be, to which all roads seem to be leading lately. So Smith asks a question in particular, a free exercise of religion question that comes up under the First Amendment to the United States Constitution, most famous for freedom of speech and freedom of the press. It also provides for freedom of religion, and in particular, for the free exercise of religion. Now, it's important to remember that the United States Constitution, including the First Amendment, are really laws that govern government. In all cases in which the First Amendment comes up, there's going to be somewhere a government actor, someone acting on behalf of the government in ways that someone is alleging interferes with key civil rights, in this case, free exercise of religion. Another important premise to keep in mind is that the federal Constitution sets up a floor, a kind of floor of federal and also state standards for protection of civil rights. However, states are free to build up on that floor. They must at least acknowledge that which the Supreme Court says they must, but it can go beyond that point, building up on those federally mandated civil rights protections to add its own additional protections at the level of the state. The big controversy we're going to be looking at with the question that's before us, which is the question of overruling a case called Employment Division v. Smith, which I'm going to refer to as Smith. The big controversy in question is this: should religious rights be more robust or less robust? And in particular, should the right to exercise one's religion be so strong that sometimes it permits religious believers, based on their conduct affiliated with their religious beliefs, to get exemptions to laws that apply to everybody else? So should you be able to get an exception to the rule on the grounds of your religious belief when it comes to your conduct that's anchored in that religious belief? The court for many years said that you should, and so 3 cases, Sherbert, Thomas, and Yoder, held that when it comes to free exercise of religion, that's a very strong right, and unless the government has a compelling interest, and whatever it's doing is narrowly tailored to that compelling interest, a test known as strict scrutiny, unless that's the case, the government can't keep doing what it's doing, and you get to have an exception to whatever rule it is. So to give you an example, in Wisconsin v. Yoder, the Yoder family, an Amish family, argued that their children should not be required to go to public school between the ages of 14 and 16. The court applied strict scrutiny, asking Wisconsin to proffer its compelling interest. Wisconsin did. It said that it has an interest in educating and making responsible citizens of those who live in the state of Wisconsin. And the court acknowledged that that was a compelling interest, but then went on to note that 14 to 16-year-olds actually get a pretty good education traditionally within the Amish community. And so it doesn't, the state of Wisconsin is not needed to make responsible citizens out of them. In other words, although the Wisconsin state interest was compelling, requiring the children to attend public school as opposed to educational opportunities in the Amish community wasn't going to make them better citizens, and therefore it wasn't narrowly tailored enough to pass the court scrutiny, and the Yoder family was permitted to pull their kids out of Wisconsin public schools between the ages of 14 and 16. So a rule that applies to everybody else is exempted for a family, in this case, that asserts an objection based on religious belief and conduct associated with it. The other side of this debate argues that the free exercise, of course, protects religious beliefs and conscience, but not religious practices. If your practice, if your conduct conflicts with neutrally enforced, generally applicable laws, you have no right to continue with it. Now, this is a nice bright line rule that sort of cuts through an area of great confusion, because as you might imagine, when you're using strict scrutiny in a balancing test, there's a lot of analysis, and it's case by case, and results differ, and it's a complicated question. Here, it's not complicated under Smith, not so complicated. Rather, as long as there's a neutral law, even if someone's religious conduct is no longer permitted, it's okay for the government to do its thing, and there is no free exercise violation if it does. So the law before Smith, in essence, was that government must accommodate religiously motivated conduct, not just religious belief. And then after Smith, the law was that a generally applicable criminal law raises no free exercise issues at all. States will have to satisfy heightened scrutiny only when a law specifically targets religious practice. Now, this is very different from what the court was doing prior. This 1990 case really changed the game. At the same time, the court never overruled any of its prior cases. Rather, it tried to sort of burrow its way around them using some, in some cases, tight distinctions that we'll talk about a little bit later. And now I'll talk a little bit about the Smith case itself. Again, all the way back in 1990, two petitioners asked whether it's appropriate for the state of Oregon to deny them unemployment benefits when they had been fired for using illegal drugs for religious purposes. In particular, Galen Black and Alfred Smith, who were both drug rehabilitation counselors at a place called ADAPT, had been hired in part because they were ex-addicts. And because they were ex-addicts, signed an employment contract that said that if they used drugs, they could be laid off for misconduct. They did use drugs, and they told their employees that they had used those drugs, but the drug they used in particular was peyote. They didn't use much of it, and they used it in the context of a religious ceremony at the Native American church. And they argued that they should not have been denied unemployment benefits because of religious conduct that was affiliated with their sincerely held religious beliefs. They were denied unemployment benefits after they had been fired because they had been fired. So unemployment benefits in the state of Oregon are not available to those who have lost their work because of misconduct, only those who have been fired not for cause. Keep in mind that that state action requirement, so the fact that they were fired by their private employer was never the constitutional issue. The constitutional issue instead was whether it's appropriate for the state of Oregon to deny unemployment benefits based on that firing, when that firing also had to do with their violation of a state criminal law. So keep that in mind, because employment benefit cases are always entangled. There are those sort of two levels. There's what happened with the private actor and what happened with the state. The Oregon Supreme Court, reviewing the case, considered that Oregon's compelling interest, or proffered compelling interest, was preserving the financial integrity of a compensation fund. That is, the state didn't want to give away unemployment benefits even to people who had behaved badly at work and should have been fired, but rather wanted to preserve the integrity of that fund by limiting those who qualified to those who were most deserving. The court argued that this state reason was not sufficiently compelling when you weighed, on the other hand, Galen Black's and Alfred Smith's free exercise rights to eat peyote in keeping with their religious beliefs. Now, the Supreme Court, reviewing this case, as it turns out for the second time, held 5-4 on behalf of the state of Oregon. That is, the Supreme Court held that it was appropriate for Oregon to withhold unemployment rights under the circumstances, even though that peyote use, the court did not deny, was conduct in keeping with sincerely held religious beliefs. Justice Scalia said that unemployment rights or unemployment benefits should not be granted, and also that the court should stop using this strict scrutiny test and just say that whenever there's a general law of neutral applicability, free exercise doesn't apply. O'Connor penned a concurrence in which she agreed with the outcome, that is, it was okay for Oregon to deny benefits, but disagreed with the reasoning of the majority, saying that strict scrutiny was a carefully built doctrine that needed to be preserved. The Blackmun dissent disagreed both with the majority's outcome and with the majority's reasoning, and started its opinion saying, I don't understand why we're abandoning this carefully crafted doctrine that we've developed over decades. And just to give you a sampling of what the Smith Court said for itself, laws are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may with practices. In essence, this is that conduct belief distinction I was talking about before, and the court also trotted out a concern to permit a man to excuse his practices because of religious belief would make the professed doctrines of religious belief superior to the law of the land, and to permit every citizen to become a law unto himself. So really, the rule of law was threatened if we readily permitted religious exemptions. So unless you've got government literally targeting, hounding religious adherents, then it's inappropriate to grant religious exemptions. It's a real outcome of Smith. So however controversial Smith was within the courts, and indeed within the Supreme Court, based on the splintering of the concurrence, majority, and dissenting opinions, it was even more controversial outside the court. It resulted in many, many pieces of legislation. The federal Congress in particular almost immediately enacted something called RFRA. This is from 1993, the Religious Freedom Restoration Act. The restoration is bringing religious rights back to where they were before Smith, in essence. So trying to get things back to where they were under Sherbert. RFRA legislated in 1993, but then in 1997, RFRA was struck down under with the power of judicial review, was struck down as applied to the states. It still applies to the federal government. And then Congress went back in and flexed its muscle, its RFRA muscle, as much as it could, considering City of Bern, and passed RILUPA, which is the Religious Land Use and Institutionalized Persons Act. So, for example, if you're looking at a case that has to do with zoning disputes or inmate disputes and free exercise, RILUPA applies. In addition, some 21 state versions of RFRA were passed. State constitutions were in some cases amended. In other cases, state legislation was passed that went specifically to religious rights. And so we went from a place where this is what the law of free exercise looked like in the United States to this kind of patchwork of laws. This is an even more detailed guide. We just have a great deal of diversity in the United States of America right now when it has to do with free exercise of religion, specifically on this question of whether one can get an exemption to neutral, generally applicable laws when a law interferes with one's conduct that's tethered to one's religious beliefs. Lots and lots of jurisdictions have said, yes, you should be able to get an exemption to such laws. There are some laws that are higher than the law of the land. And then other jurisdictions stick more closely to the Smith approach. Now, there are lots of other spaces. This is a map that indicates diversity of legislation, or diversity of the law, I should say, when it comes to a minimum drinking age. In some cases, maybe it's best for local jurisdictions to make decisions rather than federal ones, but others would argue that the federal government under the United States Constitution should well set up a meaningful and uniform federal standard, federal floor that describes the scope of free exercise rights. At any rate, the question of the day is whether Smith should be overruled. Just to let you know, overruling a case that is the Supreme Court's decision to overrule a case, would always violate its principle called stare decisis. Stare decisis, in essence, means that the court doesn't change its mind. It sticks with what it has done before, and in that way shores up authority, predictability, and credibility. It's an important and governing principle that usually wins the day. However, in some cases, the court will overrule itself, and the court has formalized what would cause it to think that was a good idea. So if the court finds that a given case, a precedent, was poorly reasoned, if a court finds that that precedent is not workable, that is, that lower courts can't understand it or follow it, if a court finds that there have been legal or factual changes such that the precedent obviously isn't doing what it was supposed to, or if the court finds that there are no important reliance interests at stake, the court will be more likely to overrule itself, violating the principle of stare decisis. So you'll see these factors at play as the students argue to overrule the case. So you'll hear reference to them. It's time for those of you who don't want to hear the story of how we came here this semester, this group of students. You can tune out now and just push stop on the video, but some of you wanted to hear about how we got here this semester. The tradition in legal studies is to pick a case that's on the current docket of the Supreme Court and brief it, even as the Supreme Court is considering it during the spring semester. And then usually at oral argument, students are covering a case that has a decision published shortly thereafter by the Supreme Court. This case, we came to ask the question of whether to overrule Smith this year because the case that the students picked was Kennedy v. Bremerton School District. So this is Coach Kennedy right here. He is a football coach at Bremerton High School in the Bremerton School District in Oregon. He has a religious belief that calls for him to enter the football field after a game when the audience is still present and pray on the 50-yard line. And he did this for some years before receiving a letter from the superintendent asking him to stop and citing concerns that the district didn't want to be affiliated with religion in violation of the Establishment Clause, and so to please stop. Kennedy didn't stop, though. Kennedy's lawyers alerted the media to the fact that his school district was trying to get him to stop praying in this way, and then the media came to games while Kennedy continued to go out onto the 50-yard line and pray. As you see, this is a media-swarmed prayer session of high school football players. This went on for 3 games before Kennedy was placed on paid administrative leave. Then he was recommended not to be rehired. He therefore brought suit against the school district. The Supreme Court, reviewing the case, held some 12 conferences. We were pretty sure that the court was going to grant cert because there were so many conferences, but that didn't happen. However, something curious did happen, which is this. The Supreme Court, in denying certiorari to the Kennedy case, opted to include a set of remarks, not formally an opinion, but a set of remarks penned by Justice Alito and joined by Thomas Gorsuch and Kavanaugh, stating, in essence, that Kennedy should have made stronger free exercise arguments, and speculating that he hadn't done so because he had thought that Smith was in the way. Indeed, neutrally applicable laws, neutral laws of general applicability were in place in the Kennedy case, and so he may have decided not to argue free exercise because he thought it was a losing argument. The court urged him to go ahead and do so, and in doing that, intimated that Smith is on the chopping block and ready to be overruled. So aside from the massive controversies that we saw earlier in this presentation, there's also this outright statement from the court that intimates that Smith's time has passed. That's from 4 justices, not a majority, but still a good beginning for one. The third road that leads to Smith is one that started last year with the case or rather the decision in the case, Masterpiece Cake Shop v. Colorado Civil Rights Commission. This is Jack Phillips, owner of Masterpiece Cake Shop, a bakery in Colorado that denied service to a same-sex couple who had gone there and requested a cake in celebration of their same-sex marriage. Phillips turned them down, saying that it was against his religious principles to speak on behalf of and in favor of and in celebration of same-sex marriages. The couple argued that he, in doing so, had violated the Colorado Anti-Discrimination Act, or CADA, which calls for anyone who hangs out a shingle to the public in Colorado not to discriminate on the basis of disability, race, creed, color, sex, sexual orientation, marital status, national origin, or ancestry. This is a neutral law of general applicability. And so under Smith, there's no free exercise argument. However, Phillips and Masterpiece Cake Shop argued that never mind that there was no free exercise argument directly, there was a violation of free speech here. He argued that his cakes were speech, symbolic speech, and that being compelled to bake a cake and decorate it on behalf of a same-sex wedding was like being compelled to speak in violation of the First Amendment. And then he made another interesting argument, and this is where I come back to how the Smith court managed to stand on its feet despite the fact that precedent moved in an opposite direction. So the Smith court stuck with stare decisis. It didn't overrule those previous cases that had applied strict scrutiny. Instead, it distinguished them, suggesting that they were different, right? So Wisconsin v. Yoder, that case about the Amish family, was different, the court argued, because there were parental rights in place there. So it wasn't just a free exercise case, it was free exercise plus parental rights. And so that made the outcome go differently. That called for strict scrutiny. The court also said that where free exercise rights are bundled with free speech rights, that may create what's called a hybrid exception. And so in arguing that his cake, that his frosting was expressive and that his cakes are symbolic speech, Phillips was in essence also arguing out from under Smith, saying that this was a hybrid exception. It wasn't just a free exercise case, it was free exercise plus free speech. Now, far from deciding on the question of whether frosting and cakes are speech, far from deciding on whether Phillips had qualified for the hybrid exception under Smith, the Supreme Court instead ruled under free exercise, plain and simple, that there had been a violation from Colorado when they had spoke in a discriminatory way when they had spoken in a discriminatory way against Phillips's religion. So the court punted on the broad questions that were before it and decided very narrowly that in this particular case, because of remarks from a commissioner named Diane Rice, it was appropriate to say that the state had not been neutral toward religion in adjudicating the anti-discrimination claims, that rather the state, because of one commissioner's remarks, had treated religion with bias, and therefore the neutrality had been knocked out, and there was a violation of free exercise. And so the court found for Phillips and Masterpiece Cake Shop. Therefore, nobody knew the answer to those broad questions, like, are cakes speech? Is compelling a baker to make a cake for a same-sex couple compelled speech? Is there a hybrid exception under the Smith case? We didn't know any of the answers to those questions. And yet this year, there's another case, almost exactly like Masterpiece Cake Shop, except I don't think we have discriminatory remarks from commissioners in this case. It's called Klein v. Oregon Bureau of Labor and Industries. Klein is affiliated with, is the owner of Sweet Cakes by Melissa, which refused service to a same-sex couple for a cake that was related to their same-sex wedding. The bakery was then fined $135,000 and I think went out of business as a consequence. Oregon argued that under Smith, because the state anti-discrimination legislation is neutral and is generally applicable, there is no question of free exercise rights. The is a great deal like Masterpiece Cake Shop, except I don't think we have the discriminatory remarks from a commissioner. Anyway, not to my knowledge. And petitioner has responded in part by arguing that Smith's time has come. So it's time to overrule Smith. Smith never worked and doesn't work. And so this jurisdiction, this state that still is bound by the Smith precedent, is arguing to overrule Smith. So in other words, we have three different directions, all of which bring us to the question of, should we overrule Employment Division v. Smith? One is the massive controversy that has always surrounded the case. Another is the question, as raised by the justices themselves in response to the Bremerton case, of whether Smith is good law. And the third is this question under the Masterpiece Cake Shop cases of whether free exercise is being properly thought through by the Supreme Court under Smith, and this strong argument that it isn't. So all three directions having come together converge on this one question. We thought it'd be fun to work it out with you, and thank you so much for your help in doing so. I will acknowledge that it is not ordinarily before the court the question of whether it should overrule its case, at least seen all by itself. So we styled this case as in re Employment Division v. Smith. We realize that this is fictional. It's a fictional posture before the Supreme Court. At the same time, because this question of overruling Smith is coming up in so many different contexts before the court legitimately, we in essence have isolated it out from those different directions and brought it together in this one question. Should Employment Division v. Smith be overruled? Again, thank you so much for participating and supporting the students. I look forward to seeing you at oral argument. Don't hesitate to be in touch in the meantime.